Hello friends, welcome once again. The Supreme Court Historian channel has finally arrived at the Rawat case, the case for which we have had a significant build-up, where we have looked at precedents given by the Supreme Court in previous judgments, which was the Chiranjit Lal case and the FN Balsara case. We have finally arrived to 27th February 1952, the Kathi running Rawat versus state of Saurashtra case. The difference between this and those two precedents, Chiranjit Lal and Balsara, is that this was a criminal case. It arose out of a spate of robberies accompanied by nose cutting and murder by marauding gangs of dacoits. I have underlined a few words on this slide. The purpose of that will become clear in a few minutes. The problem faced by the state of Saurashtra, or certain parts of the state of Saurashtra, were these bands and gangs of dacoits who were deliberately raiding people and their residences and their places of work, and they were committing heinous acts of not just robbery and theft but also nose cutting, chopping off people's noses, and also murder as well of many. So the response given by the state of Saurashtra to that was amending their public safety measures. A new ordinance was promulgated, the Saurashtra State Public Measures Third Amendment Ordinance 1949. A reminder that Saurashtra used to be a state back then until it coalesced with some part of the Bombay state to become Gujarat, and the rest of the Bombay state along with central provinces, some parts, and some parts of Hyderabad became the state of Maharashtra as we know today. This Saurashtra state, as it was then, promulgated this ordinance to tackle this problem of these marauding gangs of dacoits. The ordinance established special courts of criminal jurisdiction in those particular areas where these dacoits were prevalent. These special courts would try certain classes of offences in accordance with a simplified and shortened procedure. The point made by the state government was that these special situations demanded some sort of a special treatment, and therefore special courts of criminal jurisdiction apart from the sessions courts and the magistrate court that we already have. Apart from that, special courts were established to try these specific offences in these specific areas, and these special courts would have a different procedure than what was prevalent under the then criminal procedure code. That criminal procedure code, of course, has been amended later on, but anyway, Saurashtra state amended it for itself for certain parts of, so for certain areas, certain districts, to try certain offences, and simplified and shortened procedure was established for trying these certain offences in these certain areas by these certain special courts. Now for the underlined words and phrases, because they are going to make a difference in the arguments made before the court, especially by the state. The idea was that there was a very reasoned classification done between dacoits and gangs of dacoits on one side and marauding gangs of dacoits. Marauding meaning that they were deliberately setting out and seeking places to rob and people to kill. So there was an act of deliberation and intent over there. Special courts, not just your typical courts, in certain areas, not the entire state, to try certain classes of offences. So there was plenty of classification, and as we have seen in Chiranjit Lal and Balsara, as long as there is a reasonable classification, it is going to be difficult to overturn a legislation just because it on the face violates Article 14. But anyway, this particular individual, this gentleman, if we should call him that, Mr. Rawat, who was arrested under the provisions of this ordinance, decided to challenge its constitutionality. Decided to challenge the jurisdiction of the special court before which he was being prosecuted. He challenged it before the special court, which refused to intervene. So he took it to the High Court, which refused to intervene as well. So he finally took his case to the Supreme Court, and it arrived before the court along with a similar case from West Bengal, which we are not discussing, not today at least. The arguments made by Rawat's legal counsel were that the same offences, had he or somebody else committed them outside the specified area, they would not be tried before the special court, they would be tried before the regular sessions court. Those offences, had he committed them outside those specified areas, he would be subjected to a trial by jury. A trial by jury, on the other hand, was denied to him by this new ordinance. A reminder to our viewers and listeners, of course, that trial by jury does not exist in India any longer after the Criminal Procedure Code was amended in the 1960s. Also, there is an important stage in a trial before it is committed to a sessions court. There is a significant inquiry that is carried out, and then the court will decide whether the matter before it is worthy of committing to a sessions trial. This inquiry was also set aside in the case of these special offences in these specified areas that were being tried by these special courts. So there was plenty of discrimination according to Rawat's legal counsel. So the petitioner's arguments are quite straightforward and easy to understand. The state's response is almost complacent by now. We are in that stage where it was very difficult to overturn anything before the courts. The court was usually siding with the words of the constitution and the words of the legislation. So the arguments made by the state were basically in the nature of just turning up and winning the match, and that is indeed what happened. The first argument was that the impugned ordinance satisfies the procedure established by law requirement as prescribed in the A.K. Gopalan judgment. A.K. Gopalan, of course, stated that as long as a legislation which violates the personal liberty clause of Article 21, that legislation was passed according to the procedure established by the law, then that cannot be challenged, which was the case over here as well. But the more important argument for which we are taking this video deals with Article 14 and equal protection claims. Under that Article 14, the state claimed that such equal protection claims are examined with the presumption that the state action is reasonable and justified. The legislature must possess wide power of classification when making laws operating differently as regards different groups of persons in order to give effects to its policies. The state is bound to have to come up with certain policies to deal with certain circumstances where they would have to necessarily classify between individuals or between offenses or between jurisdictions or areas, and all of that is part of the legislative power of the state. These are not very different arguments than what we have seen. As I said, by this time the state simply had to turn up in court and repeat what they had been saying for quite a few times, that Article 14 is being misinterpreted by the petitioners. The petitioners claim to be saying that there should be only one law applicable to absolutely everybody. That is not what Article 14 says. Article 14 says that the state shall not the state shall ensure that there will be an equality before the law and equal protection of the laws, which means that equals will be treated equally. Women will not be arrested between sunset and sunrise. People below the age of 18 will not be allowed to vote in elections or will not be allowed to enter into contracts. All of these things are discriminations. All of these things have some reasoning behind them, and the existence of a reason should suffice when dealing with this kind of discrimination, and that is indeed what the Supreme Court agreed with as well. In its opinion, the Supreme Court held that the ordinance did not violate Article 14, the reasoning being that the circumstances which govern one set of persons or objects may not necessarily be the same as those governing another set of persons or objects. So the question of unequal treatment does not really arise. Unequal treatment can only be claimed when same circumstances are governing two different individuals or classes. Over here, the circumstances were different. Further, I'm going to quote this paragraph from the opinion. We can discover a guiding principle within the four corners of the ordinance, which limits the application of the special procedure to a particular category of offences only. The court was basically satisfied that this classification was actually ensuring that it is applicable to only certain category of offences. It will not be haphazardly applied to offences outside those that were defined. And the ordinance also establishes such a nexus between the offences of a particular category and the object with which the ordinance was promulgated. There was some objective behind the promulgation of the ordinance, and that objective, the court found, was being met by the categorization or the differentiation or the alleged discrimination in the ordinance. And that nexus was sufficient to repel the charge of discrimination, and it was sufficient to furnish some justification for the special treatment of those offences. The court was, in short, basically stating the basically self-realized truth that all of us understand, is that the purpose of Article 14 is to ensure that there are no privileges, there is no unnecessary positive discrimination being provided to certain classes, like the aristocratic class or something like that, like the zamindars or something like that. The reason why the French Revolution took place, for example. As long as that is ensured, then Article 14 is not violated. At the other end of the spectrum, when we speak of these negative discriminations, those are allowed as long as there is a justification, and that justification is well described in the impugned legislation, which the court found was to be the case in this particular situation. And thus we have another judgment of the Supreme Court, a very famous and important landmark judgment, which upheld a particular legislation, although on the face of it, it could be argued that it was violative of Article 14. So this ends our first chronology of Article 14 cases. We will look at the next set whenever that arrives, and I will end this particular video thanking you for viewing and for your support. Take care of yourselves. See you again next time. Bye bye.